Hi there, I'm Satya Mooland, and it's now it's 1 o'clock here, so it's 5 o'clock there, and
This meeting is being recorded.
Oh, yes. Hi, hello.
who do we have in attendance?
Well, I'm the senior appellant, and the junior appellant is also here, Miss Anushka Menon. So I think we're also going against the University of Reading.
So we're waiting.
Yes, that's
Oh
correct.
gosh, I can hear myself back in my computer, so I'm just trying to adjust that. Give me 2 minutes.
Yeah, no, of course. Take your time.
Meeting is being recorded.
Hi, can you hear me still?
Yes.
Yeah, we can hear you.
Oh no, I can still hear myself. That's going to be really annoying. See what's going on. Right. I can't hear myself now. Can you still hear me?
Yes, we can hear you.
Okay.
We
Plugging in different fora because before it wouldn't work through the ordinary link. So I opened Zoom, and now I think I'm logged in twice, doing feedback.
Yeah, we can hear you, but
This is not ideal. Let me try something else. Hi. So we're still waiting for Reading, are we?
Yes.
Okay. And the other judge, I think, not joined either.
I think the audio is just a bit muffled, but I don't know. Maybe that's just
My audio. My audio is repeating itself. So I hear myself reverberating.
Oh.
Yeah, it's really weird. I wonder if it's because Najat, if you turn off your audio, can I just try that for a second? Hello? Yes, it's that. Okay, that's what it is. That sometimes happens. I used to teach online quite a lot at university, and it could be when two audios are on, sometimes you can hear yourself back. So we'll just have to manage that during the Moot itself. I can see Delvin's joined. I'm not sure whether Delvin is our additional judge or...
No, Satya, I'm just here to check in if everything is started.
Please proceed.
No worries. We're still waiting for Reading at the moment. So, yes. So only the appellant is here at the moment.
Okay. So that's the University of Reading that still needs to join?
Exactly,
Okay,
yes.
let me
And
check
the
with the
second
team.
judge as well.
Yeah, so the second judge is not joining, Satya. It will be only you for
That's
this
okay.
session. But we'll
No
check with
worries at
the
all.
second team. Thank you.
Thank you so much. Thank you. Okay, so what I suggest for the appellants is to just have a breather, and we'll just wait for Reading. And as soon as Reading are here, we'll start, if that sounds good. Okay, lovely. Right, well, I'll just turn off my microphone and camera for now, and then I'll make introductions and we'll start then. Hi everyone. We've had some news that Reading are not contactable at the moment. They may have pulled out. We're not entirely sure what's going on. I've been told by Delvin to continue the session. So we'll be hearing submissions on the appellant today. I'm really, really sorry about this. It's really far from ideal. And, you know, I'd prefer it if we could find a team to step in for you guys so you could have something to respond to. What I would suggest though is, have you had the respondents bundle and had an opportunity to look at it?
I think we may have the respondents bundle from our teammates who are the respondents.
From your own team.
Yes.
Right. I wonder. Oh, could you just turn your microphone off for a second, just because there's a bit of feedback. Sorry, I keep hearing myself. I wonder whether you could integrate some kind from the other side into your submissions, perhaps at the end. And it's totally up to you two. So if you'd rather do a rebuttal at the end, and as if you were against yourself and you were responding to your own respondents' arguments, or if you want to push yourself even more, you could try and be responsive in your submissions, and I will mark you accordingly. What do you think? Would you two be prepared to do that?
I think because we've already done a round, so like I've sort of established an argument for a rebuttal. I think personally for me, yeah, like explaining maybe my points to counter argue what the respondents may have said would be best. So Anushka,
would be
do you agree?
Okay.
Yeah, so I would, so I would basically just, I think I can do that too. I can just restate my rebuttal from the previous round.
Lovely. So why don't you both have rebuttals? I just want to give you both the opportunities, you know, you deserve. And I think it's a shame that the other team haven't turned up today, given all the hard work you've put in. So I just want that discussion with you. Obviously, you tell me what you would prefer, and we'll do that. I just don't want to limit you. So if you're both happy to do, well, I limited the time of my other teams to 30 minutes in each team, rather than 45 for the whole team. I'm not sure what you would prefer, but I'm happy to do 45 minutes and then feedback afterwards, because you've got time now. Or sometimes with mooting, it's better to keep it quite concise, I find. So it focuses the mind, and I'm not sure if you guys are going to fill the time of 45 minutes effectively. So what would you prefer? 30 minutes overall or 45?
I believe 30 minutes may be able to cover everything that we need to say, because I was going to say that for me, I would need around 15 minutes to state my arguments, and then Anushka and then my junior appellant would take 15 minutes to state her arguments as well.
Okay, so it seems like you need slightly more than 30, because that doesn't include rebuttal, I assume.
Oh yes, that's correct.
Right, so you guys are going to do 15 minutes each, and then I think usually it's just the senior appellant that does a rebuttal, am I right?
Yes, and I would like to reserve, I think 3 minutes for rebuttal should be fine.
3 minutes rebuttal sounds good to me. I prefer a short rebuttal. Would junior appellant also like to do a rebuttal?
If time allows for it, then sure. But I mean, I'm perfectly okay with just letting Najat do the rebuttal as well.
Perfect. So this is all for your training and experience. So whatever you feel is going to develop your skills further, it might be good if you try and do a rebuttal anyway. Should we say both do 3-minute rebuttals?
Sure. Yeah.
Yeah. Perfect. I've just seen my phone is over there, and I want to keep time, even though you two should be keeping time. So I'm just going to go and grab it. Right. Are you two happy with keeping the cameras off, or wouldn't it be better with the cameras on if possible?
Honestly, I'm fine with either one, but if you'd like us to turn our cameras on, that's absolutely fine.
I would prefer cameras on. Perfect. Right. So before we start, I think I ought to give you some background on who I am and my background. So I am a pupil barrister in London at 36 Commercial. It's part of the 36 Group, which is a very big chambers in Gray's Inn. My background is I have a PhD in international arbitration and international law. I also participated in the Viz Moot as a successful oral finalist in Hong Kong and in Vienna 2013-14 as an undergraduate, and then I coached teams subsequently to that. I have arbitrated lots of pre-moot, so I've got quite a lot of experience judging, and I've also taught advocacy and mooting at Westminster University. So I have quite a lot of experience. I'm early on in my career, but as a barrister, but I do have substantial experience in advocacy training specifically, and I take a real interest in helping students develop and trying to give you really helpful feedback. So I hope that I can do that today. I will be making judicial interventions, and they may range from questions on the law that were a bit unclear, maybe in submissions, to maybe challenging you on what I perceive to be a better argument, seeing if you can think on your feet. And these are the kind of judicial interventions you may get from a judge in real life, or you may get during a mooting competition. And I suggest, because there's some feedback, when I intervene, I'll turn this will be tricky. So ideally, if I intervene, if you could both mute yourself for 2 minutes, that would be ideal. But if that's too tricky, don't worry about it. I suggest, so we'll start with, is it Najat? Yes, okay. So we'll start with you for 15 minutes. If I do intervene, there might be there's some feedback for me. I don't know if there is for you. So if you could, I know it might not be ideal to mute, but if you could do that, that would be really helpful. So when you're ready.
Okay. May it please the court, my name is Ms. Najat Mustafa, and I appear in this matter on behalf of the appellant, Mr. Leif Payne. Together with my learned friend, Ms. Anushka Menon, I will be addressing the first ground of appeal that examines whether the first instant court erred in concluding that DIFC court had jurisdiction over the claim under Article 5A(1)(b) of the Judicial Authority Law, due to Clevity operating in a distributed ledger with a node in the DIFC. My team, I've already said how to divide up the time. So before presenting my submissions, I will state the facts of the case for the benefit of the court. Clevity is a digital trading platform where users can trade cryptocurrency through distributed ledger technology. And the distributed trade was a transaction that occurred in a node within the DIFC. Clevity requires all traders to maintain a $50,000 US dollar minimum cash margin, or they will be excluded from trading.
Sorry, intervene for 1 second. I have a question about your facts. The transaction occurred within the DIFC. Did it? Are we clear on that in the facts?
Yes, the facts stated that the transaction occurred within a node within the DIFC. So the node's location was in the DIFC.
But isn't it disputed what the transaction was?
Sorry, Your Honor, could you repeat the question?
Yes, so isn't it disputed what the transaction was? Because isn't the question of jurisdiction somewhat dependent on the question of whether the transaction happened via a node in the DIFC?
I apologize. Yes, that is correct. Because if the location of the node was in DIFC, then that indicates that DIFC would have jurisdiction. But then this particular transaction occurred on the node, and it's mentioned that the node is located within the DIFC. However, as I go on in my argument, I go on to explain why node's location is not relevant to determining jurisdiction. Yeah.
Thank you. Please
continue. Thank you. Users use algorithmic trading, which creates pre-programmed instructions for automatic trading. And the respondents program, alpha, and the appellants program, beta, have preset instructions on buying and selling YAPL, which is a type of cryptocurrency. Alpha buys YAPL from beta at a price based on the average. And additionally, beta offers to sell YAPL at a highly inflated price if no other users are offering to sell it. During an upgrade, while both parties were unaware, the platform wrongfully excluded market users who had less than 200,000 US dollars. So as a result of that, the only people that could trade on the platform were the appellants and respondents. Beta sold 100 YPE for 250 times greater than the average price to Alpha. And the respondent filed a claim in the DIFC's Digital Economy Court to void the disputed trade under unilateral mistake, and claimed DIFC did not have, I apologize. The appellant issued an application challenging jurisdiction and sought immediate judgment in his favor on a point of law, arguing that there were no grounds to void the disputed trade. The court of first instance found in the claimant's favor, stating that the DIFC had jurisdiction under Article 5A1B of the Judicial Authority Law, and citing the 2011 Al-Khurafi and Bank Saracen case. Furthermore, they held that when assessing Mr. Payne's knowledge for the purpose of Article 37(1)A of DIFC contract law, the court did not need to examine the state of mind of the programmer when designing the program. They applied the reasoning of Lord Mance in the 2020 Coin PTE Limited and B2C2 Limited case.
What's your position on jurisdiction, though? So are you arguing that there is jurisdiction or there isn't?
I'm arguing that the DIFC does not have jurisdiction.
Okay. So your issue that the node was in the DIFC isn't a fact that's really in your favor here, is it?
It's not, but I also go on to explain that because Clevity is private blockchain and operates on a centralized yet distributed ledger, location of the node doesn't really play a very big role in assessing jurisdiction, and that control and authority in the node, in the platform resides with Clevity. It does not reside with the nodes, and that's included in my submission.
Thank you. It's very clear. Okay, you can proceed with your submission.
Thank you. I have 3 submissions I would like to put before the court today. For my first submission, I would like to address the case of Kiefer Alimentos, S.A. the CV, and AMS Drilling Mexico, S.A. the CV, and others, reported in the 3rd volume of the 2019 All England Law Reports on page 979. This case is located on page 18 of the court bundle. Would my lady like to hear the facts of the case?
Only insofar as they're relevant to your argument, so not in great detail. You could make your argument and then tell me the relevant facts if you deem that necessary.
Okay, thank you. Then I believe that I will just state the legal principle and assessment that derived from this case, as they also dealt with an issue regarding jurisdiction. The Court of Appeal's decision as to what must be considered in assessing jurisdiction is mentioned in the legal article titled, quote, English Court of Appeal confirms 3-part test for jurisdiction disputes, unquote, written by James Wagner and Hans Christian Mehrens, located on page 19 and 20 of the court bundle. The article explains what occurred in the case and states that in order to obtain permission from the English courts to serve proceedings on a foreign defendant, a claimant must show the court that, number 1, there is a serious issue to be tried and the claim has a real as opposed to fanciful prospect of success. Number 2, there is a good arguable case that the claim falls within a prescribed.
Sorry, counsel. I understand what the test is, and I've read your submissions with great interest. Why are we applying common law here? Is the starting point not the judicial authority law and of the DIFC? And why should I base my decision on the application of the common law here?
Your Honor, I believe that it's stated at the bottom of the problem that was given to us that the DIFC often uses common law from leading courts around the world. That includes the courts in the United Kingdom, and And due to the DIFC not holding jurisdiction, I believe that attempting to find jurisdiction in the judicial authority law would be invalid and would also not really allow me to create a sufficient argument. So applying the common law.
I understand why the common law is, let's say, authoritative, although not determinative of your jurisdiction. But nevertheless, we are still in the DIFC court and we do still have to interpret the judicial authority law. So it might be possible to interpret the judicial authority law in light of the common law, but you can't supplant the court's jurisdictional ambit as defined in judicial authority law with the common law, because the DIFC wouldn't do that. But I would like to hear your argument, and I would like to see if I could make a decision based on that.
Thank you. And the second part of the assessment is that if there's a good arguable case that the claim falls within a prescribed jurisdictional gateway, that English law governs the contract in dispute. And the third factor examines whether England is the most appropriate forum to hear the claim. Therefore, it is my respectful submission that the assessment of jurisdiction established in this case should be adopted by the DIFC Court of Appeal. The DIFC regularly utilizes relevant case law from across the globe, from prominent common law courts, meaning that the assessment may be used. And furthermore, it will enable the Court of Appeal to decide whether DIFC has jurisdiction over the legal action brought by the claimant. When applying the assessment to the current case, my learned friends may be able to argue that the first component may be fulfilled. However, it is evident that the DIFC does not fulfill the second component. As previously stated, the second component examines whether the DIFC is a, quote, prescribed jurisdictional gateway, end quote. In other words, whether DIFC law governs the contract in dispute. While my learned friends may attempt to argue that DIFC law does hold authority over the disputed contract, the nature of private blockchain demonstrates that the DIFC does not govern the contract. This brings me to my second submission. For my second submission, I would like to draw the court's attention to the information in the research article titled Permission Blockchain, written by Jake Frankfield under paragraph 2. This article is located on pages 30 and 31 of the court bundle. Paragraph 2 states that a characteristic of private blockchain is that, quote, administrators maintain an access control layer to allow certain actions to be performed only by specific participants, end quote. It's mentioned within the case facts that Clevity chooses to exclude users that fail to maintain a $50,000 cash margin in their accounts. Therefore, Clevity can be defined and categorized as private blockchain. This is really critical because a key characteristic of private blockchain is that it's centralized. This is explained in the research article titled A Detailed Review on Blockchain and Its Applications, written by Akash Khatri and Karthik Patel under subsection titled Types of Blockchain. This article is located on pages 27, 28, and 29. The subsection explains that private blockchain is, quote, a network that is centralized due to the fact that only a single organization controls it fully, end quote. This diminishes the argument that the DIFC may have jurisdiction based on the node's location. Authority is not distributed across nodes in private blockchain, as this is a characteristic.
What about the wide wording of Article 5 of the Judicial Authority Law? I appreciate Council has really, developed their argument in relation to the common law, and it has some merit. But say I was the respondent and I was saying, well, Article 5 encompasses transactions and incidents, and that can be the basis for a contract, and that would encompass a node because the transaction occurred partly in the DIFC, and under the Judicial Authority Law, it's so widely formulated that why shouldn't I then be able to have jurisdiction over such a node?
Well, Your Honor, I also go on to talk about how consensus determination resides with Clevity, and it doesn't reside with the nodes due to Clevity operating on a distributed yet centralized ledger. And consensus determination involves determining the validity of every transaction that occurs within the blockchain as a whole. And this is explained in the subsection of the article that I mentioned titled Consensus Determination. And it says that a single firm fully controls the private blockchain, and the final consensus is determined by the firm and not the nodes. So the final consensus regarding the distributed contract was determined by Clevity and not the node located in the DIFC. Therefore, it's my respectful submission that the establishment of jurisdiction in Article 5A1B is false, because under Article 5A1B, it states that the DIFC has jurisdiction over contracts that are, quote, finalized in the DIFC. But due to the information that I stated, it's clear that the contract was concluded and finalized by Clevity and not the node within the DIFC.
Thank you. Continue.
So as I was saying, so the subsection explains that private blockchain is, quote, a network that is centralized due to the fact that only a single organization controls it fully. This diminishes the argument that DIFC may have jurisdiction based on the node's location because authority is not distributed across nodes in private blockchain. The previous information that I stated also concluded my first and second submission. So I'm going to move on to my first submission. I apologize. I'm going to move on to my second. The DIFC also fails to fulfill the third component of the assessment from the Elementos case due to not being the most appropriate forum to hear the case. The DIFC is not the most appropriate forum to hear the case due to Clevity operating on a distributed yet centralized ledger. This brings me to my third submission. For my third submission, I would like to draw the court's attention to the information contained in the book titled Oracle Blockchain Services Quick Start Guide, written by Yerapati, Prakash, and Acharya under Chapter 1. It's located on pages 21 and 22 of the bundle. The subsection states that distributed yet centralized systems are, quote, distributed from the location's perspective, yet the system is controlled by a central authority, end quote. Distributed yet centralized systems mirror the characteristics of private blockchain because, once again, do you have a question?
I just 25 seconds left. So if you could wrap the argument and then conclude. I can give you one more minute.
Thank you.
Oh, you're on mute. You're on mute.
Distributed yet centralized systems have the same characteristics as private blockchain because authority fully resides with Clevity. Therefore, it cannot, the argument that the DIFC has jurisdiction based on location is completely false based on it being distributed yet centralized. In conclusion, it's my respectful submission that the judgment found by the Court of First Instance should be overturned. As explained above, the assessment for jurisdiction, when applied to DIFC courts, shows that they fail to fulfill the requirements in the second and third part of the assessment. They're not a jurisdictional gateway, and they're not the most appropriate forum to hear the case. Furthermore, if the DIFC lacks jurisdiction, then the section of the judgment made by the Court of First Instance that held the contract to be void for mistake would be false, would be invalid. This concludes the senior appellant submissions. Thank you.
Thank you very much. Now we will turn to junior appellant Anushka's submissions, and subsequent to that, I think Najat will be doing her rebuttal, and then Anushka. So when you're ready, I will set the clock to 15 minutes again.
Okay, yeah, I'm ready.
When you're ready.
May it please the court, as introduced by my learned friend, Ms. Najat Mustafa, my name is Ms. Anushka Menon, junior counsel for the appellant, Mr. Payne. I will be addressing the second ground of appeal, and for the benefit of the court, I shall restate the ground. The second ground concerns the question, did the first instance court err in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that the appellant show that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was a result of an error. As my learned senior has already presented the facts of the case before us, I will begin my submissions in respect to the second ground of appeal. I will be presenting 4 submissions in regards to this. My first submission is that the court erred in the application of law regarding Article 37, Section 1, subsection A, and that there is no unilateral mistake due to which the disputed trade occurred. The second ground states that a reasonable trader should have had, quote, knowledge, unquote, of the mistake. To support the initial judgment, the first instance court had applied the reasoning of Lord Mance, who had sat as an international justice in the Singapore Court of Appeal in Coin Private Limited and B2C2 Limited 2020. And Coin was the first case in which the defense of unilateral mistake was presented in relation to algorithmic trading and forming of contracts through the same. In Coin, while assessing the criteria for knowledge of the circumstances regarding mistake, Lord Mance had argued that the court did not need to examine the state of the mind of the programmer when they had designed the program in order to qualify the contract for mistake. However, this was the dissenting opinion in Coin and was criticized by the majority for being, quote unquote, wholly artificial. However, Chief Justice Menon, in agreement with the initial judgment, refused to consider the matter by reference to, quote, what the position would have been and what the contracting parties were likely to have known, intended, and agreed to had they had face-to-face negotiations at a hypothetical on the floor of exchange meeting to enter into the trading contracts, as this was, quote, not how they had agreed to form their contracts. When applied to this case, it is not sufficient for Ms. Razi to only show that a reasonable trader with sufficient knowledge would have agreed that the trade was made based on an error. The trade had been made by deterministic algorithms, which are designed to simply trade as per their program parameters instead of forming new responses based on the market dynamics. It was the opinion of Chief Justice Menon in Coin that in cases which involved contracts or trades made by deterministic algorithms, to assess the knowledge of a mistake, the state of mind of the programmer at the time of programming the algorithm must be taken into account. When Mr. Payne had programmed Beta, he had not made the same mistake as Ms. Razi. He had not caused her mistake and did not and could not have known about her mistake. It would be wholly artificial to approach the matter from a hypothetical floor of exchange situation, as the involved parties had chosen to use deterministic algorithms to carry out the disputed trade. As the program had been created prior to the disputed trade being carried out, there was no way for Mr. Payne to have had knowledge about the relevant mistake. This is supported by Professor Go, who was the amicus curiae in the Coin case, and he had cited Nick Yeo and Joseph Farmer in mapping the landscape cryptocurrency disputes under English law, as reported in the Journal of International Banking and Financial Law. The argument mentioned is that the trader's mistake, quote, must have arisen or at least have been continuing at the point of the original trades, unquote. However, both parties had used deterministic preset programming and by practical necessity had last inputted programming well before the disputed trade had taken place. Following this reasoning, it would not be possible for Mr. Payne to have had knowledge of the circumstances of the disputed trade or for him to have changed the programming prior to the mistake to exploit it. I submit that the court examine Mr. Payne's state of mind at the time he had programmed the algorithm due to the reasons stated above.
Even though you're distinguishing, Anushka, even though you're distinguishing Coin on the basis of this being a deterministic type of algorithm, when you've got something like blockchain that is so uncertain and parties buy into that and they know that they can create the programs that they want and they have a limited set of terms, surely you need to look into the mind of the of Cleverty in this case to see what they hypothetically would have known on the floor of exchange, and therefore you would be able to identify that this was a total error and it can't be attributed to the parties at all. So what really, you're saying it's to do with the deterministic nature, so essentially the parties having more autonomy, but that surely leaves this field totally open to abuse. So why should I believe this argument based on Coin? Are there any other authorities?
No other authorities come to mind right now. However, Coin was a landmark case for deterministic algorithms and trading in the same. And therefore, I would submit that you should accept this reasoning as it has been since used in other cases as well. And it is, of course, it's not reasonable to exclude the state of mind when the trade had taken place, but it's also important to assess whether when programming the algorithm, the programmers had intended for it to exploit a certain mistake made by another party or made by the program itself.
But in this case, what other authorities do you have to suggest? There might be an obvious authority to suggest that you don't need to look into the mind of the programmer, but you can just look at what the reasonable person would have thought. The reasonable person in the position of the parties, here being Miss Rani and Mr. Payne. What's the best source for that in this case that you can interpret Article 13.7 in light of? Do you know what the provision is?
I'm not
The
sure.
Unidroit principles. The Unidroit principles.
Okay.
So that would be another argument in your favor. Okay, please continue.
Thank you. All right. I would now like to move to my second submission. The second submission for this ground is that Mr. Payne's state of mind at the time when he designed the program was not to exploit any such mistakes as the one that had led to disputed trade. I would like to draw the court's attention to Article 37, Section 1, subsection A of the IFC contract law, and its specifications for when a party may void a contract for mistake. When Mr. Payne had created Beta, he had not programmed it with malicious intent to exploit a potential mistake in the software or by another party. Therefore, he did not, the insertion of the inflated price programming was merely done to ensure that the program would remain functional in the unlikely scenario that there were no other users offering to sell Yapple and would still be able to make a profit. This reasoning was also accepted in Coin, where the judge had concluded that while the respondent's programming was opportunistic in that it ensured he would make a profit in an unlikely situation, quote, it was in no respect sinister, unquote. And this should be similarly applied in our case. In relation to Part 1, subsection A of Article 37, when Mr. Payne had programmed Beta, he had not made the same mistake as Ms. Razi or caused her mistake and did not and could not have known about her mistake. Mr. Payne, like Mr. Bonin in Coin, did not have actual knowledge of the mistake at the time it was made, nor could he have predicted the mistake which led to the disputed trade at the time of programming it. Therefore, neither did he maliciously program Beta to exploit any mistakes. He also had not made the same mistake as Ms. Razi, nor did he have knowledge about the mistake before it happened. Therefore, this contract is not viable to void under Article 37, Section 1, subsection A of the IFC contract law. I would now like to move to my third submission, which is that there is no unilateral mistake under common law or in equity, as the disputed trade does not satisfy the requirements for either. The requirement for unilateral mistake at common law and in equity was set out in Chui King Kyong and others and Digiland Mall Private Limited, as reported in the Singapore Law Report. And it states that one party, quote, must have transacted while operating under a mistake as to a fundamental term of the contract. And furthermore, for unilateral mistake at common law, the non-mistaken party must have had actual knowledge of the mistaken party's mistake. If this is established, the contract will be rendered void. And for unilateral mistake in equity, the non-mistaken party must have at least had constructive knowledge of the mistaken party's mistake and has to have engaged in some unconscionable conduct in relation to that mistake. If this is established, then the contract will be voidable. Unilateral mistake under under common law can only void a contract or trade if one of the involved parties is mistaken about the terms presented by the other party and the other party is aware of this mistake. In this case, by electing to use such algorithms to carry out their trades, as opposed to conducting the trades themselves, the parties had agreed to trade in a way in which they would not know about the trade, nor the terms under which it had been carried out. Therefore, it would not be possible. Sorry?
The parties must have also had knowledge to some degree of what would be reasonable in the market of this algorithmic trading, if they were sort of professional parties who knew how to do things. And I see weight in the argument that as a result of that, you might have expected Miss Rani to not make this program in this way, but the situation that arose was so unlikely that the reasonable person in the position of the party surely couldn't have foreseen that situation arising. So how on earth can we hold those parties liable on the ground of Article 37. It says reasonable trader in the position of the parties.
This was okay, so the programming that Mr. Payne had inputted into beta was similar to Coin in that he'd only inputted it for the purpose of letting the contract, the program remain functional under an unlikely scenario, but it is still a mistake on Ms. Razi's part if their program was not accounting for mistakes which are unlikely but not necessarily uncommon. In digital trading, this is a risk that you have to assume when you go into digital trading and you're using algorithms to carry out your trades for you.
Thank you.
May I continue?
Yes, please do.
Thank you. Due to the reasons stated before, it would not have been possible for Mr. Payne to have had actual knowledge of the mistake, and as such, the disputed trade cannot be voided for unilateral mistake at common law. In relation to unilateral mistake under equity, he also did not have constructive knowledge of the mistake, as it was established that both parties were asleep at the time that the disputed trade had taken place. Additionally, Mr. Payne had not engaged in unconscionable conduct in relation to Ms. Razi's mistake, as he would have had to prophetically determine the exact circumstances which led to the disputed trade and then program beta accordingly. As stated in Coin, quote, programmers are not expected to be prophets, unquote. Therefore, the disputed trade cannot be voided for unilateral mistake under equity, as it fails to satisfy the requirements. In summation, the disputed trade cannot be voided for unilateral mistake under common law or in equity, as it failed to satisfy the requirements for either. I would now like to move to my final submission, and I submit that the court should apply Article 37, Section 2, subsection B of the DIFC contract law to the disputed trade. Article 37, Section 2, subsection B states that a party cannot avoid the contract if, quote, the mistake relates to a matter in which, to which the risk of mistake was assumed or having regard to the circumstances should be borne by the mistaken party. As both parties had agreed to use deterministic algorithms to carry out their trades, they assumed the risk of not pre-evaluating the terms of the trade. By agreeing to carry out their trades via deterministic algorithms, both Ms. Razi and Mr. Payne agreed to the formation of contracts without reviewing the terms prior to trading, creating a consensus ad idem between the parties involved. If the proposed article is applied, then Ms. Razi must bear the mistake and may not avoid the disputed trade. For the reasons stated above, the first instance court erred in dismissing Mr. Payne's applications and should allow Mr. Payne's appeal. By applying Chief Justice Menon's reasoning in Coin, the court should find that Mr. Payne did not program beta to maliciously exploit any mistakes in the program or by other users, did not have knowledge of Ms. Razi's mistake, nor did he cause it. As a disputed trade fails to satisfy requirements for unilateral mistake, both under common law and in equity, it cannot be voided. And lastly, the court should apply Article 37, Section 2, subsection B of DIFC contract law to the disputed trade. This concludes my submission for the appellants.
Thank you, Anushka. 30 seconds to go. Great. So, yeah, well done. Najat, would you like to do a rebuttal? So, what have the respondents said? They've said you can interpret Article 5A widely. It's enough that the node was there. Flexible definitions of jurisdiction are supported under the common law. What's your rebuttal?
Thank you. My rebuttal is, in the past, my learned friends or the appellants, the respondents attempted to argue that that the argument of the DIFC not having jurisdiction due to Clevity being private blockchain was based on an assumption, and that Clevity was not private blockchain. However, I stated that Clevity cannot be public blockchain because public blockchain lacks the characteristic of being able to exclude specific users. This is a characteristic that only private blockchain possesses. Therefore, as I previously explained in my submission, authority is not distributed across nodes in private blockchain because control firmly resides with Clevity. This also means that Clevity possesses authority over consensus determination of transactions, as I previously stated, and because Clevity operates on a distributed yet centralized ledger. The DIFC node had no role in finalizing and determining the validity of the transaction, as this was done solely by Plebity, the single platform. Therefore, the DIFC is not the most appropriate forum to hear the case and is not a jurisdictional gateway. So the assessment that was set out in the Alimentos case is satisfied, meaning that the argument made by the DIFC courts, or made by the court of first instance, stating that the DIFC has jurisdiction, should be overturned. Thank you.
Thank you, Najat. And Anushka, do you have a rebuttal?
Yes. So in our previous argument, the respondents had brought up the arguments of good faith and cited other cases involving contracts which were voidable due to mistake. However, good faith is irrelevant in this, as it is in relation to on-the-floor meetings and trades. By agreeing to use these algorithms, the parties involved have agreed to trade without reviewing the terms of the trade prior to it being carried out. Furthermore, the disputed trade was not made in bad faith, as I have already established that Mr. Payne did not program Beta maliciously to exploit mistakes. Additionally, the respondent cited cases that dealt with contracts made face-to-face and is requesting that the court had previously requested that the court set aside the fact that the algorithms were used for this trade. This cannot be done, as the conflict in this arises from the fact that the trade was carried out while the parties were asleep. While the respondent had also cited Lord Mance's judgment in Coyne, I would like to reiterate that this opinion was heavily criticized in the final judgment by Chief Justice Menon, and this was also the dissenting opinion in Coyne. Additionally, as set out in Coyne, the state of mind of the programmer at the time of programming the algorithm must be considered for there to be a fair evaluation of whether there was a mistake. That concludes my rebuttal.
Perfect. Thank you, Anushka. Really, really interesting session. I think I'm going to go away for 5 minutes now, and I'm going to write up your reports and come up with some good suggestions for improvement. Really, really good session. Congratulations. I'll come back with feedback in 5 minutes. So if we come back, should we say 2:05, just to give me a few extra minutes? Oh, so 2 here, but 5, what time is it there?
6. It's almost 6.
Okay, 6:05. Perfect.
Okay.
See you then.
Thank you.
Thank you so much. Thank you.
Hi there, I'm back. Is everyone there? Okay.
Hi. Yeah.
So I've written some feedback and now I've found the bits where I think you guys can improve. I don't know if you know the criteria, but you're being marked according to organisation, structure and analysis, use of facts and legal principles, use of authorities, persuasiveness and reasoning, and presentation and teamwork. So to begin with, this is the best team I've seen. I've given you the highest score of the teams I've seen today. So you've done incredibly well. I was impressed by both of you in terms of preparation. You were incredibly thorough. You knew your arguments. You clearly knew what you were talking about. When I interrogated you, you could answer. I did feel like both of you warmed up as time went on, especially Anushka, because I asked you some questions and then I asked you one towards the end and you were really good on that one. And I just wish that you could have been as good on that one, on the earlier ones as you were on that one. But I totally understand why, and it's quite daunting having to do mooting. But because you showed the ability to answer a question in a really, really good way, I felt I should mark you accordingly and give you a high score on that. And similarly, I thought, Najat, I think your strengths is to do with presentation. I think you come across as very respectful of the judge, particularly, I think, and as well as being organised, you addressed the issues in turn, you had good structure. On structure, I think Anushka did particularly well because she signposted, and I love signposting. So she said, I'm going to give you 4 arguments and here they are. Having said that, I could follow Najat's argument equally well. But maybe think about bringing in more signposting in future. I do think a weakness is maybe on style, which is something you might not know yet because I don't know how much mooting you've done. Both of you were reading a bit too much and I could tell. So I could see you were looking at the script and I could tell you were reading it. So obviously you're off the charts on, high marks on preparation and authorities and application of law and understanding, really good. But in terms of advocacy, you should be trying to not look at your notes or have very limited notes on the page to be able to just look into the camera and be arguing off the cuff. And that's a real skill of advocacy. So you need to be doing that because I'll be able to tell the extent to which you're reading. I do think Anushka read a little bit more than Najat, so I've adjusted the scores according to that. So the main, I'm sort of going through all these different things, but I suppose I want you to take away the main things for improvement. So the lowest scores I've given you are on use of facts and legal principles, just purely because I didn't think your legal arguments were the most effective legal arguments you could have found. And I think when I questioned you on alternative arguments, you didn't necessarily think about them. So whilst you were prepared on the points that you had looked at, you needed to also have a more comprehensive approach to looking at une droit. And I don't know how much time you've had to do that. So I'm not going to be too unduly harsh because you've obviously prepared really thoroughly on what you did prepare and the points that you did make. And I thought that was done really well, persuasive. So in terms of persuasiveness, I've marked you up on that point, and I've marked you slightly down on facts and legal principles, just because I feel the law was slightly misunderstood at times. And I don't know what stage you are at in your legal education, but I think as time goes on, you'll slowly get to grips with that in more detail. So overall, I've awarded you 75 in total. So I hope that's good. So it's on the very good 7 to 8 performance, well above average, original arguments, solid advocacy skills in most areas, minor stylistic criticism. So you're well above average and really, really good. Well done. Yeah.
Thank you
Thank you so much.
Do you have any questions for me? Oh, no worries.
I think I just have a question on, I think for our schedule, we were told that we weren't going to have any arguments tomorrow because our respondents, they argued once today, and I think they have another one tomorrow. And this is our second session of the day. So do you know when we might be able to be informed as to like, if we got into the kind of the final rounds. I think it's the semi-final and then the final.
Yeah. I'm not actually involved with the organisation of this at all. I could follow it up with Delvin, but I don't know whether that would be any more effective than you guys asking. I don't know if you've got her email or could send her an email and ask her that. That might be more effective than me asking, but I can definitely ask on your behalf and try and email you if you want. But I kind of think, so you have no information about that at all?
Yes, we weren't really told as to when we would find out which teams got to like the final qualifying rounds, but I do have Delvin's email, so Miss Delvin's email. So I can email her right after this.
I think that makes more sense. Yeah, if you can do that, I think that she doesn't mind that at all. That'd be fine. Yeah, well done. And also one last thing, you were particularly good in being creative, because you were thinking about a new difficult problem and trying to apply the law, and it is really not an easy problem. So well done, really well done. Yeah.
Thank you so much. I also wanted to just say thank you for taking the time to explain your feedback. That was really helpful.
Oh, good. I'm really, really glad. Yes. Well, I'm keen to help students learn, because I was a student once and that wasn't very long ago. So you do really learn a lot from mooting, and I definitely recommend, whether or not you want to be an advocate, it's so useful for understanding the law, isn't it? And getting to grips with things more quickly, developing arguments, developing confidence. So yeah, keep going with it, and well done for coming on a Saturday. That was amazing.
Thank you.
Thank you so much.
Okay, so I'll end the call now. I'll send your score sheet to Delvin, and I'm sure you'll be informed